Madam Speaker, I rise, of course, at this time to participate in the debate in this House, debating the bill, very simply put, the Extradition Bill of 2025. And in doing so, echo the sentiments and the expressions that I'm sure would have gone before me. Unfortunately, I didn't get the full presentation of the move of the bill because I'm coming from another meeting where I was participating in an extraordinary CARICOM meeting. And so I nevertheless came in on time to lend my support to this piece of legislation. It is very instructive that the bill is before us at this time, mainly because over the years, we've had very many serious debates at the level of the government with regard to extradition of persons. During the tenure of the 20-year period that I served, we've had a number of cases that were put before us by a second country that is seeking extradition of persons who are citizens of St. Kitts and Nevis. In fact, there was a period of time when this was a very critical part of our political development and one which also tested to a large extent the resolve of our country and government, of course, to practice what is enshrined within the law in terms of extradition. So this piece of legislation, which is to a large extent a bill, not really amending any other bill, because this is a bill that stands in its own right, on its own two legs. It's a new bill that speaks to the matter of extradition. And so the part one, really, which is the preliminary part, which gives it a title, the act may be cited as the Extradition Act of 2025. It gives you in section 2 of part 1 the interpretation of the act. Section 3 speaks to the application of the act. And it says here, for the purposes of this act, a person convicted of an offense in his absence shall be treated as a person accused of that offense. B, an act or omission which constitutes an offense only against military law, but not against the ordinary law of the land, shall not be treated as an offense. And 3, C, I should say, of subsection 3, speaks of every colony, dependency, and constituent part of a country, and every vessel and every aircraft of or registered in that country shall be deemed to be within the jurisdiction of and to be part of such country. Part 2 speaks to the return of offenders to CARICOM countries. And Part 3 also speaks of the return of offenders to Commonwealth countries. And it outlines, of course, the designation of Commonwealth country. It outlines in section 9 of part 3 the extradition offenses in respect of designated Commonwealth countries. And of course, in part 4, it speaks of existing extradition treaties or arrangements. And part 5 speaks to the return of offenders to other foreign countries. Part 5, maybe this is part 6, speaks of provisions applicable to return of offenders to all countries. And it gives you here in this part 6, it says here that section 15, powers of the minister with respect to return of offenders. And it outlines the power that the minister has with regard to persons who are to be extradited from St. Kitts and Nevis to a third foreign country. And section 16 of that part speaks to the authority to proceed. Section 17 speaks to general restrictions on return. And section 18 speaks to delay of return. Section 19 speaks to arrest for the purpose of committal. In other words, it gives you a comprehensive outline of how the process must be pursued in considering request of our country to another country to extradite someone from that second country to St. Kitts and Nevis, and likewise the extradition from St. Kitts and Nevis of a person who is here but needed by another country. And it goes into that kind of details. It speaks in section 19 of the arrest for purposes of committal. In other words, the state in which the person who is requested by the requesting state, that person, the provisions are made by law for such a person to be arrested in preparation for committal. It says here, a warrant for the arrest of a person accused of an extraditable offense or alleged to be unlawfully at large after conviction of such an offense may be issued by a magistrate. A, on the receipt of an authority to proceed, most likely the authority being that of the requesting state, and B, without such authority, upon information that the said person is or is believed to be in or in his way to St. Christopher and Nevis. So the person doesn't have to be here, but the authority can act upon the fact that the person having been informed, the authorities having been informed that that person is on his way to St. Kitts and Nevis, and thus falls into the instructions, the law, as outlined in section 19 of part 6 of this piece of legislation. I'm taking this time because I think we need to understand that this is a comprehensive piece of legislation, as movers have said, and the supporters of FAR, secondary, would have said that it is ensuring that St. Kitts and Nevis is kept in line with what is expected of it as a modern state, and at the same time being part of the international community is in fact pursuing what is its obligation as an independent country within the full-blown global community that we are part of. And then section 21 of part 6 speaks of the duty of the court of committal to inform person committed of his rights. So even though the person is a different country, of course the court in whatever country he is being held for the necessary committal, that country must make sure that the court informs the person of what his rights are. It says here, where a person is committed to custody, the court shall inform him that he will not be returned until after the expiration of 15 days from the date of its order of committal, and that he may appeal that decision to the High Court. That is very, very important. In other words, even though the person has been held for extradition, goes through the period of trial, the person has the right still to appeal, as is given in ordinary circumstances. It speaks in section 22 of the custody of the person, and 23 speaks to appeal from order committing to custody. In fact, of course, the person may be in custody, has the right for appeal, has the right maybe to appeal against him being held, or he or she being held in prison, may have the legal right to ask the court for release from prison, so that at least still in the country that is being asked to extradite him or her, and then still have the legal rights of any other person, and the rights especially as outlined in legislation which we are debating today. I'm sure that there are other countries globally who have similar laws, and so the person who's held in custody has the right of appeal, has the right also of requesting the authorities for not being held in prison during the period of waiting for extradition. And so all those are rights which are enshrined within the law, and which, as we are recognizing today, are part of our own legislation here in St. Kitts and Nevis. Appeal by Attorney General, where the decision of the magistrate is such that the return of the person requested cannot take place, the court shall, within 24 hours, transmit to the Attorney General the records of the case together with a copy of his decision, and the Attorney General may, within 3 working days from the date of the receipt of such record, appeal to the High Court by an application to be accompanied by the said record and by a copy of the decision of the Court of Committal filed in the registry of the High Court. In subsection 2 of section 24, it speaks of a copy of the application shall be served on the person whose return is requested. Subsection 3, of section 24 speaks on an appeal under this section. The provisions of section 23 shall apply mutatis mutandis, and where the High Court orders the committal to custody of the person whose return is requested, such order shall be treated for all purposes other than an appeal therefrom as an order committing such person to custody. And so usually then, before one is extradited while you're going to the legal proceedings, etc., eventually, if the proceedings would have come to an end in terms of the rights of the person being totally exercised and would have been exhausted, then again the court has the power of holding that person again before doing what is absolutely necessary. And so it says the powers of the court. On an appeal made to the High Court, the court may, without prejudice to any other jurisdiction, order the person committed to be discharged from custody if it appears to the court that the following: A, by reason of trivial nature of the offense of which he is accused or was convicted, or by reason of the passage of time since he is alleged to have committed the offense or to have become unlawfully at large, and C, because the accusation against him or her is not made in good faith in the interest of justice. It would, having regard to all the circumstances, be unjust or oppressive to return the person. So the court can order that the person be released. He's not to be extradited as has been requested by the state that is making the request, and the person is released. Order of return to requesting country. 26. It says here, where a person is committed to await his return and is not discharged by order of the High Court, or of any other competent court, the minister may, by warrant, order him to be returned to the requesting country unless the return of that person is prohibited or temporarily prohibited by Section 17 or 18, or the minister decides under this section or under Section 15 to make no such order in his or her case. So, of course, there are circumstances which would allow a person to be returned under given specific cases. It says here, a person shall not be returned to any country under this act in any case until the expiration of the period of 15 days, beginning with the day on which the order for his committal is made. And I think I read something similar of that account earlier with regard to this. Now, in subsection 3 of section 16 under part 6, it says here, the minister may not make an order under this section in the case of any person, if it appears to the minister on the grounds mentioned in section 25 that it will be unjust or oppressive to return that person, or if he considers on any such grounds as are mentioned in section 17, and that the order ought not to be made. So, I take the time for us to understand that in an extradition matter, it can be a long, drawn-out process, which to a large extent will be within the spirit of the law under which the extradition is being requested. And in our case here, in our case of the Extradition Bill of 2025, the circumstances are being laid out. But Section 27, also of Part 6, is important because it speaks to evidence. It says here, in Section 1, in any proceedings under, for the purpose of this act, in respect of a person in custody thereunder, a document duly authenticated with which purports to set out evidence given on oath in the requesting country shall be admissible as evidence of the matters stated therein. B, a document duly authenticated which purports to have received in evidence. Oh, sorry, I forgot. Yes. And this is technical stuff, so, well, I will slow. So I'm now at Section 27, which speaks of evidence under Part subsection 1B, which speaks of evidence. And it says, a document duly authenticated, which purports to have been received in evidence or to be a copy of a document so received in any proceeding in any such country, shall be admissible as evidence. And subsection 1C of Section 27, it says a document duly authenticated which certifies that a person was convicted on a date specified in the document of an offense against the law of or part of any such country shall be admissible as evidence of the fact and date of the conviction. And it goes on, Madam Speaker, to outline matters pertaining to evidence. And again, I make reference because this is not a matter that you just simply get up and pull somebody out and he's extradited. There has to be proper evidence. There has to be evidence with credibility. You have to have proven evidence to some extent. And you have to make sure that all corners of the law are met if a person is to be extradited. It speaks here of in Section 28 of Part 6, handing over of property. And it outlines in this particular section that through the Commission of Police, the minister responsible may seize and hand over to the requesting country any property which may be required as evidence in that country, etc. Again, it's not only the person, but if there's evidential material that will support the case of the requesting state for extradition, then that also is handed over, is held and handed over to the authorities involving, of course, the police. It says in Section 29, discharge in case of delay in returning. It says, Section 29, subsection 1, if any person committed to await his return is in custody in St. Christopher Nevis under this Act, after the expiration of the following period, that is to say, and it outlines the specific cases. In any case, it says, the period of 2 months beginning with the first day on which, having regard to Section 26, he could have been returned. And subsection 1b, where a warrant for his return has been issued under Section 26, the period of 1 month beginning with the day on which that warrant was issued. He may apply to the High Court from the judgment of the Magistrates' Court for his defense. So it goes to the higher court. If at the ordinary Magistrate Court that request is lost, that defiance of the request is lost, then of course the higher court is appealed to accordingly. And just to say that St. Kitts and Nevis, under the previous act, from which this act I think would have gathered substance as well, we have always ensured that there is the opportunity to appeal to the higher court so that justice can be seen to have been served. Madam Speaker, Part 7 speaks of the treatment of persons who would have returned to St. Christopher and Nevis. And Part 8 speaks in a miscellaneous way of a number of things. How you remove the prisoner who is being held to and from other countries, and the enforcement of foreign punishments. Section 35 in particular speaks to the amendment of schedules. And it says that the minister by order can, in fact, amend schedules. Section 37 under this particular part speaks of transitional provisions. And then we move to the schedule, and you have schedule of offenses that are extraditable. I don't want to go through them because for the purpose of the general public, I think it's important that they be aware. Murder of any degree. So if you've been accused of murder in a state and you are requested because you have left that state where you committed the murder, maybe, and in a state which is St. Kitts and Nevis, those authorities of the country where the murder is alleged to have been committed, that is an offense that will trigger extradition proceedings on the part of the requesting state if the extradition is being contemplated. So murder of any degree, first, second, or how many ever degrees, maybe 180 degrees, I don't know. But as many degrees of murder that qualifies, according to law, for extradition to be triggered, if possible, and has to be gone through according to the dictates of this law. Manslaughter or culpable homicide, an offense against the law relating to abortion, maliciously or willfully wounding or inflicting grievous bodily harm, illicit trafficking in drugs, illicit trafficking in firearms, assault occasioning actual bodily harm, rape, unlawful sexual intercourse with a female, indecent assault. So any of these female-related acts, for example, taking place in one country, and you flee to another country, to St. Kitts and Nevis, and you think you've gotten away, according to our law of extradition, if that state where the allegation is being made wishes to have you come to that state to answer the charge that is being put against you, these sexual offenses that I've just mentioned qualify us in St. Kitts and Nevis to consider the request for extradition. So rape, unlawful sexual intercourse with a female, notice with a female, that's kind of very incomplete, I would think. Indecent assault, procuring or trafficking in women or young persons for immoral purposes, bigamy, kidnapping, abduction, or false imprisonment, or dealing in slaves, human trafficking, stealing, abandoning, exposing, or unlawfully detaining a child, bribery, perjury, or subordination of perjury, or conspiring to defeat the course of justice, arson, or fire-raising, an offense concerning counterfeit currency, an offense against the law relating to forgery, stealing, embezzlement, fraudulent conversion, fraudulent false accounting, obtaining property or credit by false pretenses, receiving stolen property, or any other offense in respect of property involving fraud. All these qualify, according to this law, for requests of extradition to be made by a requesting state as against the receiving state. Burglary, housebreaking, or any similar offense, robbery, blackmail, or extortion by means of threats or by abuse of authority. Blackmail, important. Blackmail or extortion by means of threats or by abuse of authority. And the Attorney General specifically wants me to repeat this because I believe it is critically important. An offense against bankruptcy law or company law, malicious or willful damage to property, acts done with the intention of endangering vehicles, vessels, or aircraft, an offense against the law relating to dangerous drugs or narcotics, piracy, an offense against the law relating to dangerous drugs or narcotics. A lot of what we would have had before was related specifically to the involvement of drugs or narcotics. Piracy, revolt against the authority of the master of a ship or commander of an aircraft. It's interesting. Hijacking, whether it's an aircraft or a ship. This, again, qualifies for extradition proceedings. Contravention of import or export prohibitions relating to precious stones, gold, or other precious metals. Any offense under Hijacking Act and any attempt to commit such offense. Money laundering, terrorist financing, proliferation, financing of weapons of mass destruction, etc. So this is an example of what would have been identified within our legislation that would allow us as a country to consider a request for extradition based on charges which would have been laid by the requesting state, sent to our state, the receiving state, for such compliance or cooperation. So, in other words, the government, whether it is here in St. Kitts and Nevis, that is requesting a person who would have committed an offense, we will go according to this law. But if a person is here and the person is being requested by a requesting state, of course, we also would make sure that the state which is making that request does so according to our law. And if we are making that request of that state, we have to make sure that our request falls within the ambit of the laws of the requested state. But there are cases as well where a request for extradition can be made if the person is not in the state where the offense has been made, not in the state where he is a citizen of, but in a third state, not where he is, not where he's from, but from another state. Again, those requests, when they are made, have to fall within the four corners of the law. Whether it is the law of the requesting state, where then you would assume that the offense would have been committed, whether it is a request that is made of a state where the person is, which may not be in St. Kitts and Nevis, or if the person is in St. Kitts and Nevis, three different scenarios then, the law is being proceeded with at all times. So we want to assure our citizens, and we want to give assurance to citizens who may be resident here and are being requested by the requesting state for them to be extradited to answer charges, criminal charges, etc. We are going to be guided by what this law says. This piece of legislation that is before us today in this Parliament, and which becomes our Bible of guidance as to how we proceed. I therefore lend my support to this bill. Thank you.